Hi, this is Dr. P with 10 need-to-knows about protecting your intellectual property. And this is a big enough topic that it is a two-parter. Obligatory statement: I am not a lawyer, but I have repeatedly listened to and read what lawyers have to say about this topic. And the law is pretty clear in most cases, though it tends to become obscure sometimes over time, owing to various court rulings. So I have a list of 10 things, and I'm just going to show this list briefly, and then I'll talk about each one individually. So, first of all, no one wants to steal your ideas. They might steal a successful game that you've made. In other words, make a clone, especially in the video game world. But they don't want to steal your ideas, because ideas are nearly worthless, and everybody has lots of ideas for games. Your great idea, quote unquote, not only has been thought of by many people, it's probably been used in a published game. That's the hard truth. But once a game has proved to be successful via publication, then people may use your ideas. Most likely, though, you won't have any legal recourse, because ideas can't really be protected unless they're egregious about it and make a game that works and looks just like the game that you made. So that's the first thing that newbie game designers don't get. No one wants to steal your ideas, because your ideas aren't worth much, if anything. Moreover, you can't copyright game ideas. Copyright protects only specific words and graphics. It explicitly does not protect game ideas or game mechanisms. You can find a dozen Risk clones being played online under different names. The name Risk is trademarked, and that's why they can't use the name. The rules are copyrighted, so they have to rewrite the rules. The graphics are copyrighted, they have to redo the graphics. But the game works just like Risk. Now, I will say there's been a rise recently in trade dress copyright actions, where the look and feel of two works is very substantially the same, and sometimes that can get you somewhere in court. And this started in software, as far as I know, with Lotus 123 and a program called The Twin. Get it? It was a twin of Lotus 123. And Lotus prevailed in that lawsuit many, many years ago, when Lotus 123 was by far the best-selling computer program in the world. But trade dress doesn't generally apply with games unless there's a very obvious cloning of a game, which does happen in video games, but not generally in tabletop games. Your work is copyrighted as soon as you create it. That was not true 30 years ago. You had to register something to copyright it. The laws have changed. And the laws have changed through the Berne Convention throughout the world, although there are countries where the state does not enforce the copyright laws. A copyright notice is not needed. But registering your copyright helps you defend the copyright. Without registration, the amount of money you can recover is quite limited. In the USA, you register through the Library of Congress. There's a form to fill out and a two-figure fee. And last I knew, you had to send them 2 copies of whatever it was you were copywriting. Trademarks are sometimes the strongest protection. A trademark or service mark, it protects a title or a phrase. And that generally would include the titles of games. The common law trademark, which is the TM that you see after the name of a game, costs nothing. The registration, which is R in a circle, costs 3 figures. You have to keep the trademarked item in commercial activity. That is, if it goes out of print for a long time, the trademark will lapse. So typically game titles will be trademarked. But once that game's gone out of print, you'll find another game come out with exactly the same title. Another thing that is often done is to use a subtitle to differentiate your title from the original title. And then it depends on who is willing to spend money in court whether that will work or not. The same word can be trademarked in different areas of commerce. For example, Apple computers and Apple records. But of course, once Apple computers started to sell music through iTunes, a lawsuit occurred, even though they had a prior agreement. But my game Britannia may be trademarked as a game. Well, there's Britannia Building Society in England, which is a savings and loan in effect, and there's no problem there. And of course, trademarks, copyrights, patents, they're country by country. In the case of the copyright, it tends to be respected throughout the world because of the Berne Convention. But if you want to trademark something in the United States, you'll also have to trademark it in other countries. If you want to patent something in the United States, okay, you also have to patent it in other countries. And unfortunately, patents are difficult and expensive, both to acquire, to maintain, and if necessary to defend in court. They're of limited protection for a limited time, 20 or 26 years. They cost a lot of money, $3,000 to $10,000, according to a lawyer, and that was some time ago, plus additional thousands to maintain the patent over the years. And if you have to defend it in court, you're going to pay a vast amount to lawyers, and about 2/3 of patents are invalidated in court. So you're unlikely to make as much money from your game as the patent cost, even if it's not challenged. Now, I have a separate screencast that talks just about patents and goes into more detail about this. More of this in part 2.